Welcome, everyone. My name is Brendan Cochrane. I'm a partner at YK Law LLP. I think we've got a very interesting and timely panel for you today, NFTs, IP, and entertainment law. I'll introduce my esteemed colleagues shortly, but I think this is timely because there's a lot of interesting IP and entertainment law issues emerging right now, whether it be copyright, brands, trademarks. In this year, in 2023, one topic that has really come to the forefront, I think, of a lot of the NFT community is generative AI, which we had an excellent talk on earlier in this conference. Generative AI obviously introduces a lot of interesting IP issues if you create an NFT using AI, who owns the intellectual property. Property was one of my favorite classes in law school, and I think another interesting issue that's more traditional is how NFTs challenge the concept of ownership. Traditionally when you think of ownership, you think you get a baseball card, you hold it in your hand, you store it in a lockbox under your bed, you have the key, but you buy an NFT on OpenSea, I can go to OpenSea, right-click, save as, and I would seem to own the NFT as just the same as you would. But obviously we have a very different conception of ownership due to what the blockchain is capable of, and so kind of our conceptions of what ownership means are being challenged. But before I introduce my co-panelists, I did some research into market reports and sort of trends going on right now in 2023 related to IP and entertainment law and the NFT market more generally. And I mentioned I work at YK Law LLP, and that is an affiliate of Yinka Law, which is China's largest law firm. And what I kept seeing as I was looking at sort of the trends is when you look at interest, adoption, usage of NFTs, the Asia-Pacific region often is at the countries there are often at the top of that list, and basically there's a number of reasons for that. Maybe in general, certain Asian-Pacific countries are more likely to adopt technology more quickly and more thoroughly, like when you think of the smartphone. But I also think that there might be it might be related to our legal system, particularly IP and entertainment law as well. Our IP laws are more stringent, generally speaking, than most Asia-Pacific countries, and also, NFTs present a new technology, and we haven't really gotten our legal certainty, basically, about how these laws will apply to the new technology that's out there. So my co-panelists will discuss some of the developments that will shape how the NFT market will grow here in the United States going forward. So let me introduce them. First, we have Nima Mohebbi. Nima is a partner at Latham & Watkins, where he's a trial attorney. He represents some of the top innovators, and also advises studios and artists as well. So very, very much one of the leading experts. And we also have Mark Jansen, who's a partner at Fenwick & West and their intellectual property group. Mark is known to represent in IP matters some of the top Web3 companies as well. So let me turn it over to my co-panelists. Nima, I think I'll start with you. Could you talk a little bit about what you're seeing on the litigation and regulatory front, and maybe touch on how folks can protect themselves?
Yeah, of course. Nice to meet everybody. Nice to be here. Just for the record, I am not the Cash App killer. For those of you who don't know, you're probably going to Google it now. It's very unfortunate. But it's a great question, and the short answer is a lot. There's a lot happening, both from a regulatory, I would say, regulatory and criminal standpoint, and also from a litigation standpoint. From the regulatory, I'd say criminal standpoint, obviously everyone's well familiar with the SEC, the extreme increase in regulatory activity we've seen. The interesting thing from an NFT, because we are at NFT.NYC, from an NFT standpoint, within the last year, we've seen prosecutions for NFT-related issues. There was a big one in the Southern District of New York for essentially what was termed insider trading from an NFT, a former executive of an NFT company. And then, going sort of shifting to the entertainment slash security side. I'm sure everyone, I don't know if you have or haven't, but the Bored Ape Yacht Club, the Yuga Labs, was sued along with several major entertainers, probably like many A-lists, like Madonna, Justin Bieber, in the Central District of California. It's a securities case. It's one of the most high-profile and first instances of NFTs being really accused as of securities. We're representing several of the celebrities in that case, and there'll be one to watch because I think it'll be interesting to see what early motion practice says in that case as to whether or not these are actionable securities. I think one of the most interesting ones from my perspective is the Dapper Labs case, which was right in the backyard here in the Southern District of New York. For those who aren't familiar with Dapper Labs, they essentially offer trading cards, what are called moments. They're unique NFTs that are essentially moments from NBA games. And in an order just a month and a half or maybe 2 months ago, Judge Marrero in the Southern District of New York basically denied Dapper's motion to dismiss, finding that there was enough evidence or enough in the way of allegations to say that the moment NFTs were not unique. Because essentially they were powered by a private blockchain, meaning that Dapper theoretically could control it. Now, this wasn't a final decision, but it demonstrates, I think, clearly that certain foregone conclusions that we've all thought are, kind of clear in the space, like trading cards, unique trading cards, not securities, that is not necessarily the case going forward. So that's just going to be one to watch. I mean, really is going to be one to watch because I think it's going to really set the boundaries for how these things are viewed. Kind of going to your last question, and just to give a little bit of practical input here. I've probably had about 4 or 5 new matters I've intaked every single week in the last few months. There's a lot of turmoil where contracts are falling apart, and it's kind of ironic because this space is one that has been kind of defined by sort of a sense of unity and collaboration, and that's kind of going by the wayside when the money stops flowing. And it's not surprising, it's a little sad, but what I will say, and this is just anecdotally, and maybe it's just me that's seeing this, but some of these contracts that I'm looking at are some of the worst contracts I've ever seen. And to the extent that they're even defensible, they're a complete disaster. And so, I think the advice I would give, both from an IP, and I know you're going to speak more to the IP issues here, but from a commercial standpoint, you really got to take the time. I still believe in this space. I think there's a lot of potential. I really do, and I've seen some amazing ideas, amazing projects coming out of this. But the reality is, you really just have to take the time and do it right. I think a lot of these contracts were sort of drafted in the run-up and a lot of hysteria and excitement and wanting to just get something out and get something done. I think now, given the way the market is, you have the luxury of being more careful and being more judicious with how you move forward. And so my biggest advice on that front, just hire a good lawyer, spend the time, spend a little extra money making sure that you get it right. Because while a lot of these concepts, DAOs and decentralization, they're workable, but you have to do it within the frameworks that exist. It's not enough to just say, I have this great idea, I'm going to go out and raise a bunch of money and then execute. You got to be careful. So that's a high level view, and obviously if anyone has any questions at the end, but I'll kick it over back to you.
Thank you, Nima. That was really interesting. Very interesting to see how the culture and the law relate. Mark, would you like to touch on what's on the IP forefront?
Sure. And I'm actually going to break with tradition if that's okay with everyone. I'm going to stand. I'm too old for these plastic seats. But I think carrying on from what Nima was talking about, it's such an exciting space to be in, right? Because we're sort of at the infancy still, despite being a couple of years in, right? And there are a lot of moving pieces. We're seeing, we're doing a lot of counseling on the security side of the house, the tax side of the house, right? Which is those are the questions we often get. But I think IP is so crucial here, right? Because you really need brand identity as a cudgel to stop bad faith use, which we'll talk about a little bit, as a way to prove to your consumers and community and user base that you are who you say you are, right? And so I think what makes Web3 especially interesting, though, is in the context of everything happening right now, right? There's this ethos around open source and keeping the community happy. You don't want to offend your user base, right? And you have to almost delegate accountability to some of those users. And a lot of the community members and people outside of the community aren't necessarily using your IP rights with permission or with written authorization. And so, there's this big question mark around how do you preserve your brand rights? How do you enforce? And there's already a disconnect between what we see in Web3 today and what the traditional Web2 players had done, for many years, right? And trying to keep Web3 by basically letting everyone do their thing, right? And that's going to be a problem longer term, and I think kind of consistent with what Nima was describing, right? It's in that same vein as the bad contracts, bad advice maybe that some people have given. And so I'm just going to talk through some best practices, some guidelines you may want to carry over with clients, with anyone you're educating in the space, because I think there are some things you can do that are a light lift without making anyone too uncomfortable. The irony with all of this, of course, is that having been involved with the Web2 players when they were in their infancy, they sort of did the same thing, right? No one wanted to pull any triggers. No one wanted to offend any users. Everyone was kumbaya, and eventually, they became what they are today, right? So, copyright, amazing tool, something that I think we're going to see a lot more of, something that is probably not ready. It's still being tested from a fair use perspective, from a DMCA perspective, so a lot of that isn't fleshed out yet. So I think that's why brand in particular is going to be kind of the hot tool that you're going to see more and more right now. So, without further ado, trademarks, right? What are they? Well, trademarks are, it's a source identification tool, right? It protects certain products, certain services. And the standard test is whether a reasonable consumer is likely to be confused, right? And so there's a lot there in terms of registration strategy, right? When you think about why should I register, what should I register, there is a bunch of inconsistency in terms of, you have these pre-existing brands, right? Fashion houses, for instance, that's a great litmus test because they are technology forward. They tend to be very cautious about their rights, and they're sort of in the thick of it right now. You've heard a lot of, they're in the press suing people, going after people, and they don't know sort of where their own rights lie, right? I mean, they have registrations, which means they have all these great presumptions around their rights for clothing, but they don't have digital assets, right? They haven't registered for digital assets. And so there's a big question mark. Does, Prada or Gucci, for instance, own the metaverse counterparts of the fashion items that they otherwise have rights for in the real world? And so that's sort of forming in the discussion here, and guiding the way a little bit. But I think for most, anyone kind of dipping their toes in and just getting started, things to consider, right? One, what's your launch date? When are you gonna debut? Because there are a lot of things you can do to preserve your rights, hide the ball if you don't want to disclose publicly, and if you are concerned about who's going to be first in time, because there's always a big question around who has locked in that first use date or who has filed first. You want to go ahead and get those applications on file, right? And lots of nuance around, well, where should you file? What should you file for? Trademark world is archaic, right? There are 45 different verticals that you can choose from in most countries, and they're inconsistent. Some cover software and hardware and sunglasses and fire extinguishers, and so you need to know what to pick from, right? You need to know rights are territorial, so you have to pick and choose the countries you're going to file in. A lot of countries to choose from, lots of treaties you can leverage, all kinds of things you can do. And you need to be cognizant of your corporate structure, right? What we're finding is we're dealing with a lot of companies that are offshore. That changes the whole dynamic, right? From not only from the regulatory and tax perspective, but where do you start filing? How do you file, et cetera? And it's a litany of questions, right? What's your roadmap? Who's using in your community? What are they using for? Do you need to capture those rights in your applications? All questions you should be thinking through. And you may want to do some diligence, right? You want to make sure that other people out there aren't using your brand, that someone hasn't beat you to the punch. So all part of the process. Once you get that all squared away, get the application on file, right? That's kind of the starting place. And I think in that same vein, a second best practice is make sure you have some clear brand guidelines, right? Because the community, like we've talked about, maybe you're encouraging them to use the brand. Maybe you want them to get the name out there. But you want to make sure that they're doing it the right way, right? And so you want to have a delineated list of to-dos. Here's how you can use, here's how you can't use. Maybe that dovetails with an FAQ around what the commercial rights are like. Where do they come for brand permission requests? What does your copyright license look like? I mean, you can bake in anything you want, but the key is having a set of guidelines that you can refer back to, that you can share with the community, that you can link to in any letters you send out to say, hey guys, we've put out there what the landscape should look like. Please adhere to these rules. And this dovetails with some of the licensing piece we're going to talk about in just a sec. But the third sort of prophylactic best practice is registering domains, right? And everyone knows about the OG domains, the .orgs, .nets, .com. Those have been out there a long time, right? There are CCTLDs, which are foreign domains. There are new GTLDs within the last decade. We've seen this explosion of .software, .shoes. There are thousands of them that you could choose from. I advocate for a lean strategy. You can't capture them all. You're going to have to enforce against some stuff, right? So people are going to misuse your brand some way, somehow. But we've now entered sort of a new dimension where there are these alternative domains that exist out there, right? These are, you probably heard about them, unstoppable domains, ENS, .sol. There are many, many different variations. What distinguishes these newcomers from the Web 2 traditional set is none of these are governed by rules, right? A lot of the old domains are governed by ICANN. There are arbitration processes for taking them down if they're doing bad things, right? Posting child pornography or a phishing site, right? You can't do that with a lot of the newer domains. And so something to be proactive about. I'm not encouraging that you go out there and capture all of these because, again, strategy has to be lean. But you want to make sure to grab the ones that are relevant to your business, because if you don't get them, someone else will, and it's almost impossible, as of right now. That will change, I'm sure, as time passes, right, to get those back. You can't even find out who owns them, right? That's the whole concept of the decentralized domain process. I'm running out of time, so I'm going to move to brand enforcement, which is sort of the, you've got the trifecta in terms of prophylactic stuff you should be doing. This second piece is what should you be doing once you've locked in your rights. This is how you preserve your brand, keep the integrity of those rights, right? And I mean, it's sort of a delicate balance because we've talked about this. There's this whole community aspect, right? Community doesn't like aggressive action. There's this open source mentality. So you have to figure out where do we draw that line in the sand, right? How do we avoid pissing people off while still maintaining some semblance of order? And it's not, licensing is going to be kind of one of your best bets in this space. but you can enforce and protect your rights and still grow that community, right? Don't question it. The thing that you're trying to avoid is genericide, right? And this session isn't long enough to talk about genericide, but bottom line, you're trying to avoid a loss of your rights, right? And genericide in tech doesn't happen that often. Even Google recently disproved, it was sued and was able to prove that even using Google as an adjective or a verb still doesn't count as being generic, right? So there are ways out of it, but from a practical perspective, genericide is bad, right? It will create all kinds of wrinkles for you. So what do? You start with a takedown plan, right? And what does that mean? Well, you start with the social platforms that everyone already knows about, the Web 2 platforms, right? The Twitters, the Discords. You have to monitor them, right? Make sure you're taking stuff down that's going to create trouble for the community, stuff that's bad for your user base. Monitor the new platforms that are coming out of the woodwork, right? Post Elon Musk's acquisition of Twitter and the chaos that's ensued, we're seeing things like Mastodon, right? Which is the new Twitter. Be aware of what else is out there. And then, you may need to loop in a brand enforcement vendor at some point, right? A lot of this is, it's a game of whack-a-mole. Stuff comes up, goes away, comes back up. And so you may not be able to harness that yourself. There are ways to do it. I've seen clients do a lot of really creative things where they crowdsource it, right? And they have the community go out there and look for them, and the community gets awarded for finding some of this stuff. You have to be careful. You don't want community members taking stuff down willy-nilly, right? That creates its own set of problems. There can be fair use. There can be, you don't want a PR nightmare because someone went out of their way for you, right? So things to consider. But the key is setting sort of some criteria internally, right? Take it down if it's illegal. Take it down if it's counterfeit. Take it down if it's phishing, right? Maybe that's your bright line standard. If it's a community member, if it's fair use, maybe you don't bother. You don't have to take down everything, and that's a key element to remember. Now, what goes hand in hand with this, of course, is education of the community, right? Because you want to make sure the community, it's the old adage around, new tech, old scams, right? And to some degree, it's the age-old advice about if it sounds too good to be true, it is. But I think if you've got brand guidelines posted, if you're in touch with the community, if you have verified social channels where you can immediately tell them about something that's out there in the ether that's going to be, avoid this page. This isn't us, right? Or someone got scammed. Be aware. That's how you're making sure you're keeping in touch with them regularly. And then last but not least, the piece that's crucial is some sort of licensing program. And I think we're seeing at least the big players adopting this schematic only now, so that gives you a sense of how hard it's going to be to implement this. And this can be as simple as a click wrap license, right? You don't need a detailed, excruciatingly painful negotiation with every community member who wants to print merch, right? What you need is some semblance of order, making sure that they comply with, they're not doing anything scandalous or immoral. They've agreed maybe to reference your brand guidelines. Most community members are going to adopt that, no questions asked. They love you. They're part of your atmosphere. They want to participate in the ecosystem. And so I think we're going to see a lot more mass adoption of licenses, and it's important to have that, to the extent you can get projects and affiliates and anyone to sort of agree to that. You're controlling brand ownership, right? And that's key. That's why you do the licensing piece. You make sure that their use inures to your benefit, right? And so you have rights for all the things that are being printed. If they're selling T-shirts, you get the benefit of that. And you're sort of controlling the narrative, right? So people don't do bad things with it. I think I'm about to run out of time, so I'm going to pause there. Final thoughts?
Nothing final other than, I don't think we have time for questions, but if you have questions, feel free to reach out. We're happy to chat. And thank you so much for coming out. Really appreciate it.
Thank you, guys.